Welcome to Dolly Talk. This is Dolly. Oh, how is everybody doing? Let's see. We got all kinds of people already in chat. Oh boy. Bye, Franz. You will hit the like. Yes. Don't make me make you get my belt. Subscribe to the channel. Hey, Scott. Mavka. Brad. Ah, even David popped by while he's building Legos. Look at him. We know how important Legos are to David. Yes. He will sue you over them. Hi, Rachel. How are you? Mads, Mavka, Johnny Osprey. Demon's Wrath is here. Daddy's home. Everyone gets the belt. No, I'm not pantsless right now. I actually put on pants today. I normally stream kind of in the buff, but not today. Speaking of buff. Oh, Hella removed her hand. She just looked down like this backstage. Hi. Yes. She makes some good points, doesn't she, chat? Can you go and mute yourself?
Yeah, can you stand up?
No.
I want to know you have pants on.
I have shorts on.
That's fine. Just prove it.
I don't want to show you my shorts. Because you'll see my feet.
Shorts are nowhere near your feet.
There.
Okay,
see?
right, fine. That's enough. That's enough.
God.
Thank you.
Just
Good.
trying to make
That's
me...
right.
Just wants to see my legs for some weird reason.
No. That was enough.
Mm-hmm.
Good. Shorts in winter isn't that heretical. He is in Arizona.
It's only like 40 here.
I don't know what that means. It's also, weirdly enough, it's also 40 here, but Celsius.
It's like 10, 20 year thing. Anyways, guys, today we are going to be covering... Stop laughing at me. We are covering the Billy Wagner's latest hearing.
Hang on, has anyone noticed? Look at this little troublemaker. Hello? Yes, you. Now, this is the kitten who got really, really fat. Yes, I'm cat shaming you. You. Indeed. Look. Hello, this is Suni. Suni, you want to come forward a little bit? She's going to cause a lot of trouble if I try and move her. At the moment, she's calm for about, 20 seconds. Yes, you. Oh, you're going to sleep there? Are you? Okay. All right, yeah. Anyway, her butt is like the size of my dog's butt, and the dog is a massive German Shepherd. Right? I was just saying, like, she eats all goddamn day. She's quite healthy. Anyway. Suni, yes.
Buster... Oh. Yes, on the 30th. It's just... Buster is the cold case that was cracked in Michigan. Forgot to talk to Dave about that today. I went on his late...
Not Buster Hyman.
No. That was the guy after him. But Buster... Oh, what was his full name? I have it somewhere. But he was a cold case. Woman died in 1989. And 25 years passed. He's got a family. He's got kids, grandkids, great-grandkids even. And over the Christmas holidays, he's celebrating with his family, and there's at his door. Buster Robbins. And surprise, it's the Popo.
Was
And
it an IgG case, Mavka? Really?
it was DNA. I don't know if that's how they
Yeah.
cracked it.
Well, that would. Okay, so if that's what they're doing now with cold cases, so they're getting DNA from um, way
Family.
back, yeah, and they're putting them through 23andMe and Ancestry.com, and they're reverse
Yeah.
DNA matching because if they could have put it through CODIS and
Well,
found,
they would have.
they would have, right? So there you go. That's what's happening, guys.
Yeah.
I mean, fine if they found him and it really is him, great,
Yeah.
all right? But we got no privacy. That's it. That's it. That's what these. Your DNA is. It's out there. Your family's DNA is out there. You can be found no matter what.
If your dad or your brother is arrested, charged, they get their DNA taken. It's added to a database. Well, they can find you that way.
That's not even it. That's not
Well,
about
that's true.
being arrested. It's about putting it into one of these databases just
That
to
too.
find out who your family tree is. It's not about. It's not about being arrested.
Yeah. But they
It's
can
doing
do.
something completely innocent, like trying to find out who your great grandma is.
Yeah. Well,
Yeah,
these
it's all
kids know who their
searchable.
great granddad is. He's in jail. So yeah, that's coming up. It's just a probable cause conference to schedule the hearing. I most likely, but that should be coming up soon.
Oh, really? You're adopted half Irish. There you go. Well, if you put your DNA into one of those things, which I would recommend you don't, you might find out who your ancestors are. But isn't that interesting?
Kind of wish I was adopted sometimes, but that's just about it.
I think your parents probably wish that too. Anyway.
So, anyways, what are we doing today? We are covering a hearing for the Pike County Massacre. Eight members of the Rhoden family were found shot to death in their homes just before Donald Trump won the election in 2016. Absolutely no relation, but I think the media would have tried to find a way to do that. He was associated with murder. The crime scene spanned multiple family homes throughout the area. 7 family members were found dead in 3 different homes on Union Hill Road in Pike County. The 8th victim was found within a 10-minute drive of the others. I mean, props on, they certainly didn't half-ass it. Officials said they believe the shootings took place in the early morning hours. Yeah, that's kind of a good assumption. So we got the family members dead, Christopher Rhoden, Donna, Hannah, Christopher, another Christopher, Clarence, Gary, old Gary. Oh, not old Gary. Hannah.
Clarence?
I know, and Kenneth. Oh, not Kenny Rhoden.
Oh, you totally missed my Flying High reference.
I got it.
Clear as Clarence. Over under. Roger, Roger.
So this turns out to be the biggest white trash family. Older guy has a child with a minor, and it turns out to be this whole
What?
yeah. I believe he was 19 and she was 15 when they had kids. And grandmama kind of was getting upset that she wasn't getting enough time with the baby, and they wanted custody, and it turns into this whole Hatfields and McCoy situation, and they orchestrate a plan to go unalive the entire family,
As you do.
as one does in Ohio.
Yeah. Hey,
so-
Rachel from Idaho.
Hey. So they're just going through the whole family. Most of them have pled out and said, okay, oh, Lordy, don't give me the death penalty. And give me life in prison, and I won't snitch, or I will snitch. The one guy, I believe the brother, went to trial in 22 and was convicted and got multiple life sentences. So this guy that's going to trial right now is the father, I believe. They're in jail, Mads. Just about the whole family. There was a couple lesser Wagners that didn't really have anything to do with it, but did some illegal stuff to help them unknowingly. They got, slaps on the wrist. I plan to cover this more in depth going forward, but I wanted to at least get to the first hearing that was yesterday, or not the first, but the hearing yesterday, show you the judge, and I think he's pretty based. True crime wine moms hate him.
Really? Why?
Because, how are we in this mode for now? He tends to have a bias, at least in my view, towards the defense. And he has very strict control of the courtroom. He does not allow the prosecution to get away with anything. They were having some discussions about whether the death penalty would go forward or not for the guy that we're about to watch.
Yeah.
And the judge was finally, you guys have been arguing about this and talking about it for so long. I'm going to make up my mind. We're striking the death penalty.
Hang on. So, is it that they're pleading?
No.
It's
The judge-
It's the trial.
Yeah, the judge kicked the death penalty for trial.
Okay, hang on a minute. So, when the prosecutor's trying to decide whether or not to put the death penalty on the table.
Yeah, and they were trying to
And-
waive it in front of the defense to get him to plead and to try to play some
Okay,
games.
and
with
this
it.
is what really early in the proceedings, right?
A
So
few
you
months
can't
ago.
just chuck the. No. What I mean is that you can't just waive the death penalty around halfway through
Yeah.
pre-trials, right? Like death penalty is a big deal.
Yeah.
You have to get like a mitigation expert.
Yeah.
It blows the whole thing out, right? So you can't just be like, oh, by the way, death penalty. So
Yeah.
how far along in proceedings are we when they're talking death penalty?
It was less. It was less than 6 months ago, and they were supposed to go to trial this month, but they delayed it
Okay.
again.
No wonder the judge did that then.
Yeah,
No wonder he's rightly pissed. You can't just do that. Like,
Yeah.
death penalty is a big deal. It blows everything out.
the judge. I will say, I will agree with you there. He was kind of an ass. Well, he was more blunt, I think, and kind of didn't really take. We'll cover the sentencing probably
Nasty
next
to
time.
the victim's family and just a complete ass. Well, that's a different thing,
Yeah,
right, Rachel? So I didn't see that. But in regards to the death penalty, you don't mess around with it and just decide at the last minute you're going to ask for the death penalty
yeah,
to be put on the table just willy-nilly. That's
Yeah.
not how it works, right? So, and I think the general public don't get that.
yeah. And the prosecution
and-
were not happy.
Prosecution can be as not happy as they like, but clearly they're probably working more with the popularity with the public,
Yeah,
and obviously being elected officials, than being realistic in terms of trial procedure.
Yeah.
So come on now, you can't just go, oh, hang on, we might just go for the death penalty
Yeah.
at the last minute. That's bullshit. You can't do that.
yeah. So the judge and the prosecutor have butted heads quite a bit. So,
Okay. He does sound based.
yeah. I do agree, Rachel. I mean, 10 minutes for the victim impact statements. Because, yeah, it was,
How many victims were there? I would assume there'd be a lot.
yeah, and then some more showed up kind of at the last minute. Because it's like several members of a family, so there's a lot of people
Okay.
involved.
All right. Well, I mean, I haven't seen that, so that does sound kind of shit.
Yeah.
But yeah,
But-
I mean, I'm only commenting on the death penalty part.
Yeah.
If that's how it went down.
Yeah, and we'll
Yeah.
start researching this more and get into it more. But for now, we will start this hearing.
Yeah. Let's go.
Maybe. Wrong mode. Yeah. Sound quality is not the best, but I will play with the audio as needed.
Yep. Sweet. Hey, bye, friends.
And as you can see, the defendant there is just a prime example of white trash.
He's very attractive.
Yeah. Yeah.
All right, good morning. Go ahead and have a seat.
And you'll see kind of the mannerisms of the judge. He's very old-fashioned and, yeah. Does have pretty good hair.
Okay, 2018 CR 157.
Okay, wait. Question.
Third.
Is that frame in the background painted on? Is he in a cartoon set?
Yeah. Somebody painted that, I think, on the
Look at
wall.
that! That's not real. It's like
Huh.
2D.
Yeah.
Look! What the hell's that?
Huh. It's like a Bugs Bunny or Acme courtroom.
Yeah!
Beep, beep. Yeah, the Wile E. Coyote's going to just jump out of it any moment now.
Yeah, right?
It's like Better Call Saul background.
I'm not going to be able to stop looking at that now. What the hell's going on there? This is not a real courtroom. It's a set.
Yeah.
You can unroll that thing.
A mural, yeah.
It's a mural. Oh, wow.
Okay, 2018 CR 157, Stedbaugh versus George Wagner III. So, first of
Oh, he doesn't do the Pledge of Allegiance here. During the sentencing, he comes in and the first thing he does is the Pledge of Allegiance to the flag. I mean, I appreciate that.
all, my apologies for being a little behind on the bench this morning. But I did some logistics, found out that though I'm not the administrative judge, there's a lot of decisions I make that affect the flow of the building. So I doubled back to learn more about how the building flows while I'm sitting in the front of the room.
I think he's talking about his bowel movements, but I could be wrong. He didn't have his coffee.
The
No.
scheduling from 3 weeks ago, where I have you coming in every month, is meant to be productive. But I don't know what that means to you.
Yes, he
I
does.
put those dates on so as I see work that I think needs to get done, we can get to it. But I very much would expect you to raise those issues you think are necessary. So if the defense has motions, bring them on. If the state has motions, bring them on. I'll be doing the same. You already know that I'm not reactive. I'm proactive. I'm not dependent. I'm supposed to be independent.
Okay, Dr. Seuss.
It's not about charm, because that's not part of the equation.
Yeah.
It's about the job
Clearly.
of the judge to get the trial done in a timely manner, in a fair fashion. So that's the goal, and I'll be proactive to do that, not to your exclusion. So we'll work our way through that as best possible. I've identified 3, maybe 4 topics for today. A conversational style will work, as long as we don't talk over each other or throw a stroke. Debates sometimes appropriate, sometimes not.
He's paid by the word.
In no particular order, there's a discussion and a motion by the state to amend the bill of particulars, so we'll want to talk about that. I'll have a question about election on firearm specifications and a discussion about motions to sever charges. And then I don't know what else the defense might have with regard to motions you think are coming. Same thing from the state, Ms. Canepa. So I don't know. Apologies, is it Miss Gall? Gall, thanks.
Talks more than McLeland.
So as counsel for the victims, I don't want to make you feel like you need to be outside the realm of the bar.
Hey,
Could
Phil.
we pull a chair up here for you?
Your Honor, I don't live with any victims' rights concerns or issues, so I'm fine to stay there unless you prefer my second.
No, but like I don't always see the world as you might. So I don't want you to think that I don't care about victims' rights, but sometimes when I'm
I just don't,
the
but
gallery,
I don't want you to feel
I
that
will know
way.
that there's a victim's right issue that you might want to assert that I didn't think of. So like your seating's fine with me, as long as you don't misunderstand.
I mean, as long as you don't misunderstand, I really don't care. So
We have
just,
captions.
oh, yeah.
Because, yeah, that's important.
Duly noted, Your Honor, I'll stand and beg myself back if something arises.
Okay, thank you very much.
Hey, Phil.
The state's got the pending motion to amend the bill of particulars. It's a well-drafted motion and pretty clear. Do you want to speak further to it, Ms. Canepa?
No, Your Honor, we just would respectfully request that the court grant that motion. As the court knows, it has...
And that's the prosecutor, the main prosecutor, who really does not like the judge, and the judge and her butt heads quite a bit.
Is it possible to move the captions from underneath us?
Oh, God,
Yeah.
you're really needy today.
I ask for a fair bit, don't I? Right. But,
Thank you, Kay. I appreciate that. And Rachel, you said there's a documentary, Pike County
Ooh.
on. Okay, I'll watch that actually, because I saw Billy, or the younger kid in 22. I mean, I'm not gonna comment on her looks. I will just say she should invest in a hairbrush. That's it. I mean, we all have bad days, but
You know who she reminds me of?
Morrissey.
You remember? No. Remember the prosecutor from the ballerina trial?
Oh yeah,
Yeah. How dare she be pretty?
yeah.
Yeah.
Oh, she doesn't have to worry about this defendant.
No, that's true.
The ability pursuant to Rule 7 to amend the indictment and the bill of particulars at any time before, during, or even after. Certainly,
Hold on, guys.
I have additional case law speaking, Martin, that talks about amending, if that was a rape case where the conduct itself was different. It went from either fellatio to vaginal intercourse. I don't remember which one it was.
Whoa.
But suffice to say, completely different conduct.
Clearly.
And the court ruled that it was permissible to amend the indictment to conform to the testimony that was provided at trial. So again, we provided notice to defense counsel. The point is well taken. They're not responsible necessarily to watch George's trial, but I know that they had been. But that aside, in August of 2023, we did provide them with the transcript, so they have had notice. Specifically, as I pointed out in my motion, the address is the same, the location is the same. The only thing is there's a technical difference that's in Scioto County, but it's still the same address on Union Hill Road. They've got pictures of the inside and the outside of that location. There's no prejudice to the defendant. In fact, we're providing more specific information, just that property, the street in front of it is Pike County, but the property itself is Scioto. In fact, there's a point on the property where Scioto adds in Pike and Third. And this part of this came from the Adams County Sheriff and then Pike County Sheriff showing up to the crime scene, and they concluded amongst themselves that it was in Pike County. All to say, Your Honor, not all of the counts in the indictment happened in Pike County. The preamble to the indictment states that, as does the bill of particulars, that if it's not in Pike County, the defendant is properly placed in Pike because of continued conduct of 2091.12. So again, there was notice to them that not all of these counts happened in Pike County, and that if they didn't, the state was arguing continuing course of conduct. They filed no motions, to object to them being placed in venue here when many of the other counts were clearly outside of Pike County. Wagners lived in Adams County at the time.
What are you gonna do with them, Mecca?
The defined location of the evidence. They eventually lived in Scioto County. So Adams County and Scioto County were already implicated in this continuing course of conduct. There are some locations that we don't know, and we stated that too, because we just don't have that information. But so again, I think they were already on notice that not all the counts happen in Pike County. Our way of thinking is we're not providing them the more precise information, which again, and I feel like I brought this up before and said that I would be filing a formal motion, just to make the record clean for, like you said, years down the road, and those of us present in the courtroom are home thumb, it's clear that that actually happened. So, Your Honor, again, with respect to the request of the court, permit this, additional notice of more precise as far as the county itself.
And please don't yell at me.
So who wants to speak on this?
Your Honor, I can speak on this. We appreciate the opportunity to reiterate some of the points that we've had in our response. Primarily, this is a concern for timing. The state became aware of this specific fact during the trial that occurred in 2022, and this formal filing occurred here in 2025. We were set to start trial just a few days after. This was raised on the record at our last hearing, and then formally filed on the 10th of January. Criminal Rule 7 obviously provides a wide breadth of timing that the court can consider this amendment, Your Honor. But given all the circumstances of this case, how long ago these homicides happened, charges were filed, pleas were entered, trials were conducted, verdicts were rendered, Your Honor, this is a late in the game amendment request. Your Honor, for also due process reasons, what was presented to the grand jury information is also of some concern. For those reasons, what we raised in our response,
Is she Amish?
Oh.
In street language, I would say, why does it matter? In lawyer language, I would say, what's the prejudice?
Your Honor, it's somewhat difficult to determine exactly what the prejudice would be given. Our concern of what was presented to the grand jury, what precise information was granted or presented. To your point, however, we have not filed a motion to contest the venue based on the location of the address in question here. However, this case has been going on for such a long period of time. This raises questions: what else hasn't been addressed? What other concerns are there out there that haven't been addressed leading up to trial?
The rhetorical question.
Yes.
Rhetorical question is whether you're entitled to a perfect trial or a fair trial. Like, don't answer that, because that's for me to work through. I understand what you're saying, but very much the legal standard is, why does it matter, i.e., what is the actual prejudice? I can't speculate about what may or may not yet be done, although I worry about that and I push ahead, and I'm trying to do that in this whole case. I can't do the abstract, I have to do the real. Okay, anything else?
No.
Mr. Hayes looks like he's ready to jump in, or that's just putting with your glasses.
Just move my glasses.
Okay. Any response or anything else to what Ms. Knapper?
No, Your Honor.
Is the audio really bad for you guys? I'm playing around.
It's a bit low. Is there anything
Yeah.
you can do about it?
Oh, I can try boosting.
Hit the like to fix the audio.
Rachel, I think basic problem the prosecution had was forcing sentencing on some of them, gave no incentive for them to testify against the others. Dolly, maybe you can explain that. Yeah, that was weird because two of the family members had plea deals to come and testify against this fine gentleman right there. And in exchange, the state wouldn't give them the death penalty. Well, the judge was like, well, they took the plea like a year or two ago. So they were just sitting around waiting for him to go to trial. Judge just wanted the sentencing to be done with and off his calendar. I don't know yet how that's going to affect this trial going forward, because technically they've been sentenced without having met without the defendants having met all the conditions of the plea agreement.
Sorry.
Oh, they already testified for the other brother in his trial. That's right. So they have the testimonies from that trial. So I suppose in theory, the judge figures they could just use that testimony. It was still very weird that he was so adamant about doing it.
Maybe we're better up here
Okay, thank you.
for now.
Yeah. It would have to be impeached, that's true. So we'll see how it goes, what happens going forward. That was a good question, thank you. And I'm...
Now
Oh,
put
now-
Susie back at the bottom. Yeah.
Damn it. God damn it, guys.
I can't do that. He has to do
Yes.
that.
And I'm trying my best with the audio. It usually to enhance it, unless like Fuel Hammer's here, there's a little bit of a hum, but I'll try to do what I can.
So you get a written decision. The focus is going to have to be necessarily, why does it matter? I have to articulate the prejudice. Like, it's news to me that at different times the Wagners lived in Adams County and then Scioto County also, correct? Is there any way of like tracking address times? Like, do you know when they lived at certain locations?
Well, I could get that to the court, Your Honor, I can't tell you off the top of my head, but at the time of the offenses, they were living in Adams County. At the time of their arrest, they were living in Scioto County. And evidence was retrieved from both counties. The forgeries, we believe, happened in Adams County, and I have to look at the indictment, but, there were times where we said, multiple locations, known and unknown, which are by some manner enumerated in 2901.112 of the Wagner Code, whereby proper venue is placed in common pay. So, that's throughout the indictment. In some of these where we didn't know, right? So we knew that they took property from Pike County, from crime scenes, and they destroyed them in Adams County. But then they ultimately were recovered back in Pike County at a Flying W, Billy's mom's house, things like that. So there were multiple counties that were involved in this. That's never been a secret. That's put in the bill, particularly in the indictment. So again, I cannot imagine what they would do differently sitting here if the court were to allow it. Then there'd be nothing that would be different going forward. Because again, it's the same location, it's the same address. Some things we knew with more specificity, others we just didn't even know where it happened, right? We knew they took it, we didn't know where they destroyed it. We knew they, the prior calculation and design, which is an element of one of the offenses. Angela testified that Billy would come pick up the boys and they'd go off driving, and so again, Your Honor, I don't think they're harmed or prejudiced in any way. The argument is the same whether these 4 counts happened in Scioto County or whether they happened in Adams or Pike, because they already knew that there were multiple counts involved, or counties involved.
Anything else for the defense? I need to circle back on the last motion, which was the defense's request for clarification on other acts testimony. I think we all know this. Last month it's a bit more edgy for a lot of different reasons, but the relevance is the first part of the analysis. Obviously, if it's not relevant evidence, then you don't even consider other acts because it has to somehow be related. Relevance is also thought of as what are the crimes alleged, i.e. what are the elements of the crimes alleged. So that makes me then go immediately to whether severance of charges is a part of the analysis. Like, I'm anticipating what's common and likely, I'm trying to get ahead of the curve here, is like, do I consider severance of charges? Let's just use your example, Ms. Connect, for forgery. If forgery happened in another county and severed out, just pick a reason, I don't care, it's not in, I'm not saying it would be. Well, then if forgery is not an element, we don't hear testimony about signing a document because it's got nothing to do with all the other offenses. Like, I just want to go back to law school. I might be talking to the audience now, not the lawyers. But in the consideration of other acts, am I also then supposed to consider severance of charges? Go ahead.
Yeah, we anticipated that you would be discussing that. We were looking at potentially trying to sever out several counts that don't fit into the state's theory of in theory of motives and things of that nature that may or may not be relevant. And AMST's been working on that, and so we were kind of looking at some of the, like you said, forgery, tampering, and things of that nature. So if we could have, I think you're probably halfway through the analysis. prior to the next status conference, we may have something filed for you on that. If we don't have a good faith basis, Your Honor, we're not going to waste anyone's time with that. But we are researching that based on what you indicated and based on what was provided to us with the May 30th date and that kind of agenda. So we are going down that list and looking to try to adjust those events.
Okay, so you just did two things. You used the word may and then walked it back, neither of which is wrong. But I'm not doing it that way. So I want your perspective, because we get into this tug of war at every court hearing, is who drives the bus, right? Is the court reactive or proactive? Well, we already know me. I'm pushing ahead for everything that needs to get done so we don't get a decision from the Court of Appeals and then have to do more work. You asked me last time when, and I said short notice, because we ought to be ready on short notice. I don't have a schedule. It's too far out. There's too many moving parts. You've got more than one case. I've got more than one case. I don't know about Mr. O'Brien or Mr. Knapp, but we got to figure that out. But I'm going to push ahead. So you file your best theory on severance so the state can respond to it. The state can file a request to sever also, as much as the court can bring it forth on its own. So give me your thoughts so I don't have to guess. So I'm asking for it.
Because I don't think that's fair.
Yeah, no, and I appreciate that.
What we're thinking, haven't formally
Yeah, that's okay.
put everything together.
I'm not ready to do anything. I just want to, I'm already there, so you might as well talk to me while I'm there.
What we're considering is the tampering with evidence counts regarding phones, cameras, other items belonging to the victims, custody documents, which counts 15 and 16, forgery of the custody documents, count 18, unauthorized use of property, count 19, that's the social media accounts, an interception of communications, count 20. What we're starting from is the information we provided about Mr. Wagner's involvement within those specific counts, whether his specific conduct had anything to substantiate those particular counts. For example, with the custody documents, forgery of those, I believe at George's trial, information having discovery, Angela, Jake, and George were responsible, and Rita were responsible for the conduct that constitutes that act. So, for example, we would consider requesting the court to sever that count from the trial. Also, with the social media accounts on unauthorized use of property, I don't believe that there have been allegations testified to at trial or in discovery that Mr. Wagner logged into anybody's social media accounts or once in those accounts sent any messages surreptitiously. So that's sort of the theme that we're kind of working on right now. As to case law supporting that, as to statutory considerations, we need to be forth out, and we will in a formal motion. That's generally where our thinking is.
15, 16, 17, 18, 19, 20.
Yes, Your Honor.
Yeah, thank you. Like, I'm not going to put you on the spot, Mr. Knapp. I just need to know, I need everybody to know I'm already thinking about this. So, like, when I suggest that you don't get it, like, maybe suggest something, it's because I'm already there. I'm not smart. I'm actually not the least smart person in the room as a lawyer, but I have to get ahead of the game because it takes me longer to learn. So, thanks for the briefing. Like, all the briefing in these motions has been well supported, very helpful. And then I look at that and I go get my own answer, and I double check your sources, and I sometimes find that there's a split. And then you have your theory of the case, she has her theory of the case, Mr. Bryan's got his theory. We all do, but we got to get it done. So that's why I'm asking for you to, I may completely ignore it, I might drink it all, but I'm already there, so give me whatever your logic is. In fairness to me, I didn't see Miss Gall until I found a notice of appearance and a notice of appeal from an interest that I never even knew was complaining. Like, nothing personal. Welcome to the party. But I would have liked to have heard you tell me there was a concern before the notice of appeal. You don't have to do anything. Nothing wrong happened. But every assignment of error starts out the trial court error. And the theory of the practice is we try to help the judge not err. So, like, that's why you don't
He's
get
trying
to
to help
show
me
up
not err.
sometimes. Your limited appearance was rejected. You're in because I don't want to have, like, an interest be asserted after it's too late for me to address it. Like, thanks for the advocacy. You're doing what you're supposed to do. Had the advocacy happened before the decision, we might not need to be on appeal.
I think he's
These
cool.
lawyers up front, just all have to do the same.
And I hate all
From
judges.
myself.
I know.
I don't intentionally.
I really
err.
hate judges. This one's all right.
And you're
like he'll get super strict at
Yeah.
times, but he's
Yeah.
always really calm and then just goes back and talks and just, okay.
Yeah, okay.
Job is to make sure
I
I
like
don't.
him.
So they
Yeah.
And
Like-
I like that he's self-deprecating. I'm not this. I'm the least smart person in the room. That's cool. He has a sense of humor.
Yeah, he's not
Cool.
like stuck up. I mean, we'll see how you feel after watching the sentencing. I'll probably do that next. In the next.
I mean, okay. So I mean, I haven't seen the sentencing, and when we say he was an ass to the victims, 10 minutes per victim is a fairly long time to speak,
Yeah. And to
unless
be
he was
fair,
actually mean to them.
he also limited the defense time too, and how long the defendant had
yeah.
to talk.
Well, okay, but people will say, but he's the defendant. Fuck him.
Yeah.
You know, I mean, there's not unlimited time
Yeah.
for the court, so I hope he was not rude
No,
to the
I don't
victims.
think so.
Yeah, but yeah, there is an unlimited time. There's not. It's not like the court can just stay open all day for days and there's not other things on the calendar. So he has to limit their time. He can't just have people coming in and speaking for hours and hours and hours. It's just not. It can't be. I mean, yeah, I don't know. So far, I really like him.
Yeah.
the extent that you can. And I don't expect the state to agree with the defense. Now we're talking philosophy here. I'll own my decisions after everybody hears what I need and tries to guide me through it. That's why you don't get a suggested motion. I'm telling you, brief it, because I don't want to go off on my own. And maybe you've done enough right now, Ms. Anstead, to tell me what your logic is. If you want to put it in a one-paragraph motion to make it a nice record, that's another way to do it, but I wouldn't develop 30 pages of research. It's your pleading to file, so I can't tell you what to do. I can simply tell you that I need to have this because that's where I'm thinking. That's just me. Go ahead.
To answer your first question in general, I think there's going to be an ongoing struggle back and forth and tug of war about trying to include Billy in the other acts that other family members did, that there's no evidence to support that we're going to try to disassociate them. So that's going to be a common theme with the other acts and with the settlements and things of that nature. So that's what's coming your way. I don't think you disagree with that, right?
No.
Right.
I mean, obviously, the particular ones are the case that can be tried on complicity. Right?
Has she got a mustache?
We do it to be
In
a
terms
part
of
of it.
conspiracy, in terms of that, that's going to
The RICO broadens the thing a lot. The conspiracy broadens the case a lot.
If she did,
Or
she
maybe-
wouldn't.
They're there at the end.
If she did, she
Maybe-
wouldn't shave it.
And I don't say that with any,
I
like,
thought, okay,
glibness.
maybe it was her
No, it's
hair
all
from the
about what
other
the charges
side
are.
coming forward this way,
I think it was her hair.
right? Like if I went like this and my hair just sort of started to come this way,
Yeah.
like a false mustache.
Yeah.
Wow.
When we go to trial. But, like, I got to work my way through because you want a solid answer on other acts. In fairness to me,
Rachel.
in August, when I didn't make a thorough record because I wanted to have a chance for the lawyers to get to know me, i.e., I want to know you, I don't think I said on the
So high up.
record, we're not spending 10 weeks on this case. Because I read through the record and saw a lot of evidence that had some relevance, but maybe not enough to warrant boring the jury. And Ms. Canepa said, no, this is a different case, or she would try it differently. Whatever your response was, you acknowledged that because a lot of water had gone underneath the bridge from the first trial when I got here last August. Yeah, like we're all going to be looking for, strike that, I'll be looking for efficiencies. I don't know what you're looking for. So, like, very much so, we want to have, like, decisions that you can rely upon. Some objectivity, not show up and throw something against the wall and see what sticks. Like, I'll do that. Because I have to enforce my own rules. So I'm going to try to be as, like, objective as possible so you can tell me I didn't follow my own guidance. Anybody else want to talk further about severance?
Your Honor, if I might.
Yeah, Mr. Bryan.
Yes, Your Honor, I think maybe the best way to proceed on this and others is the court just set a deadline, file a motion, and we'll respond, and then the court can move on, and we'll all know where we're going.
Brilliant. If it was that easy.
But I don't know why.
No, it's not, because I can't let a deadline get in the way of due process.
At least on severance, Judge, I think from what Ms.
Oh, did you hear what he just said?
Address that by issuing file motion.
Can't let out.
Go talk to Kranik. I can't let a deadline get in the way of due process. Quote
Yeah.
that, put it in a picture frame and put it on the wall. I love it. I can't let a deadline get in the way of due process. I love that. Okay, this judge has just won me over. I like him. Nice.
I mean, he certainly goes above board when protecting their rights, and
Nice.
that's pretty rare.
Okay, now yes. Hella's in love. I mean, he could piss me off any second. Judges tend to do that, but I like that one. That was a good quote.
Yeah.
You sent another
Exactly.
song?
Yeah, the timing
Maybe.
will be there. And honestly, like, I don't know what we're going to do in February. I just marked you a date that I could call you on Wednesday before Friday saying, I don't see a reason to be here to you.
Is this dude Lisk?
We'll consider the matter submitted on the pleadings. I just wanted to hold your life, not use it.
Hey,
So we don't look over the top of
Rexy.
it.
How's it going?
I don't know your schedule.
It's
Mr. Brown.
Rexy's
I know
brother.
you're a lawyer, an experienced lawyer, but like I hear from the defense that they've got more than one case, and they got judges expecting them to be there. So like me holding dates was to capture your attention, but maybe not have to actually use the time. So 2 weeks, Ms. Anstead? 2 weeks after that is fine? Okay, so then we're there. And I don't like necessarily have to have a oral argument, but now I want to go into like whatever motions you think you still might want to talk about. Both ways.
One mistake has, I think, Your Honor, that we haven't filed yet would be a motion for jury view. And perhaps, as the court suggested, the defense has other motions that they anticipate filing, that the court find out what kind of deadline may apply and then deal with it that way. As the court said, efficiency would work better if we could resolve all these before.
Do you think of anything else? Like I'm tracking that one because that's a part of.
Well, change venue implicates.
No, I'm 3 months ahead of you. On
I
that
thought it was
issue,
3 months ago too.
you weren't here. I know, but I was. And as soon as I can ask on my own motion to change venue. Like I wasn't constrained by the prior judge's decision. Never was. Never will be because the rules say on motion of the plaintiff, the defendant, or the court, venue can be raised. I didn't do anything wrong to raise the issue. I'm going to get stuck with how this flows, so therefore I'm proactive. Is that the third time I said that? Yes,
Yeah,
that's me.
I understand.
Yeah, it's not wrong, it's philosophical. The rule says I should do it. I thought of that as soon as I raised the issue. It's theoretical to raise the issue, it's practical where you're going to go. And I'm hunting. Okay, like I got shoe leather invested in where this goes.
Shoe
Venue
leather?
was on my mind in October and September. Venue was on my mind in other cases that I've tried that they cited back to me like they should have, because I told them about it. I agree with you, but what else is it? Like, tell me whatever else you think I got to look for, because venue's part of it, right? Oh, by the way, any place I move involves the sheriff and the bailiffs and the clerk of courts and the jury commissioners. I get this.
No, and I think the
Yeah.
court's being proactive. So the only thing that we think is out there for us is that jury view. And I don't know what else the defense may have, but
Yeah.
the court suggests a deadline, and all parties will be ready to go when the appropriate times arises.
Wait till you read my current theory on jury view. Well, just make sure you're sitting down.
Well,
I worked my way through it. I understand what you're saying. I sat over there for a lot of my career. 3 years over there, 14 years over there, 27 here. They're all different views.
Wow.
It's a hash. But in my mind, get ready.
well, and that's why I raised it, so at least the defense does the same.
Yeah, I'm getting ready to go there and ask them what they want.
Would they want to make that motion for jury view?
That was in the, that whole motion, I believe, so I think those have been dismissed. But, you know, as any case, this whole, our concern is the jury was not reflective of how it was back in that day. And there's different building systems and things, some things have changed. And so anything you file will address.
Yeah. What else do you think is coming at me with regard to your issues? I mean, you're right, Mr. Collins. I tossed all your motions. I'm cleaning the deck. I'm going to clear the deck. But that doesn't mean we're done because we got to get it right.
I think that as a group, we talked about, Your Honor, The only other potential thing that would be found would be defects in the indictment in regards to the bill. The defects in the indictment we may have, and I apologize for using that. As a defense team, we talked about filing some type of motion to dismiss certain things in the indictment as they reflect to the RICO or the conspiracy things that nature. So that's, as a group, when we've updated our time, that's something that we're also going to investigate. That, in terms of procedural motions, that's probably the only one that I don't think we've talked about it in that.
Add one to your list. Add this to your list.
Okay.
Add this to your list. What did State versus Beatty do to the indictment? Beatty was the 24 decision that you can only impose 2 firearm specifications, right? I just have to eat that decision, apply it. I don't have any problems with the logic. It makes sense to me. But does that then change the quality or the relevance of evidence? 6 times 2 is as bad as you can get.
No, exactly. And I think the state disagrees with you on that, or disagrees with that case, but.
I get that. Totally. Why don't, maybe not. You don't have to agree with it. I think that's the law, and you can do it as you want. But I
Again,
think
those are things, how they elect are things that potentially could go into that type of thing. I understand what you're saying. in the law.
Yeah. Like I counted at one time, the current indictment has, how many of the 79 verdict forms?
Jesus.
79 verdict forms. You take every spec under every charge, you give a verdict form on every spec. Right? Now, there's an instruction for every one of the 79 verdict forms. Right? Like I started jury instructions a long time ago. I can't tell you, but I'm not up to triple digit pages yet. Oh, by the way, you're going to ask X number of everyday ordinary people to come in and comprehend what you guys went to law school and practice a long career to understand. My job is to fix that problem because we don't have a jury of lawyers, we have a jury of average people. So, like, consider what State versus Beatty did, if anything, and how that plays in the indictment, because you charged it before the Beatty came out. And I'll be looking for what's relevant. And if it's only a sentencing philosophy, then maybe it has nothing to do with it.
Understood?
Yeah, then you have the whole idea of just making it clear and fair. And how does that play out? So, work on that one. Ms. Canepa? Anything?
No, Your Honor. I mean, we're familiar with the safety baby.
Yeah.
But I believe that's just a sentencing issue.
Well, not everything's not just, because everything's all put together. I get what you're saying. I'm not asking for a commitment. This is when my brain has to run, so I don't get run over at the end of the case. Anything else on your list that you want to talk about? Any record you want to make?
No, Your Honor. We'll file our motion for jury review. And we'll respond to any motions that they will file.
Mr. Hayes, Mr. Collins?
Your Honor, a couple
What's
things.
at Easton, Habarish?
I think that the first thing is, that this is housekeeping. Billy is having a very difficult time hearing anything. It's not the volume, but it's the clarity. I've spoken to his mother, and we're trying to obtain a certain type of a clarification hearing aid, and I made an order from the court allowing that into the facility where he is in custody right now, and things of that nature, but I'm sure that I can make that happen. That's one thing. But hearing in the courtroom, wherever we end up, is going to be a huge thing for Mr. Wagner. In terms of some counties have headphones that amplify. The amplifier is no good for him. It has to be a clarification type situation. So that's just kind of a housekeeping matter to let the court know that I'll try to follow up with that in the court order, things that nature, if we do that, if we county jail, if we need that. The main thing I think, and I'm not speaking for the prosecution, but we have not practiced in front of you in a trial. It's the only time any of us are in front of you. So the main thing to me is the report your process and the logistics on there. And I've talked to Ms. Canepa about a concept that I've used several times in how you get type cases, and where basically the questionnaire is filled out, copies get returned to us, have them come in on Thursday or Friday to fill out the questionnaire. We then take the copies at the end of the day once they're made. Each side then comes up with a list of individual jurors that they would like to talk to, say Monday morning, for example. And the reason the individual talk is because they said something in their jury questionnaire that we don't want other jurors to hear or to voice the potential, things of that nature. So we would exchange probably, there might be 20 individuals that we need to talk to about, let me back up. The first thing is we address, and I'm sure we've done this many times, commitments of time, base, work, all that type of
Court
stuff.
reporter has a woodgy
On
face.
Thursday or Friday, court take meeting with jurors. And then once they complete the questionnaires, we would then take them and submit the list to the court, the joint list, which says, hey, we want to talk to these 30 individuals. And we would alternate doing individual work here, and just about that concept only. So whether they know something interior, whether they, how much media, we're relegated only to that individual topic that we identified from the questionnaire. Basically what it does, Your Honor, is it gets all the cause bumps done in advance. So then let's say we have a final group of 60 people, then we're in no danger of running out of jurors potentially to get the panel of the alternates. And then also, Judge, maybe we could put this away, but your policy on bumping, shooting jurors, whether it's in front of people, how you move into the box and things of that nature. So I think that would be helpful for all of us, just so that we can feel more comfortable and be more efficient during that process.
I think my current case management order is 21 paragraphs. That isn't enough, but I'm trying to anticipate how we're going to do this, what it works out to be. So because everything you're talking about is exactly right. Like, I know how I'm going to try this case, but that doesn't help anybody. You know, we're past the point of being able to delay. I'll get increasingly more assertive. Good luck with that. I'll tell you exactly where to stand and where you don't have to stand, so you don't have to guess. I want the jury to understand we've tried a dozen cases together last year, which means you understand me well enough and I understand your expectations. Like, I think this courtroom is a theater, and you ought to be able to use the theater of persuasion to do the law. So I'm not going to anchor you to a podium. That's just me. That's how I wanted to try a case. Till you mess with the court, and then I'll figure out how to deal with you. Till you cross a line that you know you shouldn't cross, then I'll deal with you. Like, it's your case to try, but we have to try it right. That's the fairness aspect of the court's duty. So yeah, like, I don't have a problem with sometimes asking you to argue your objection in front of the jury, because then it makes more sense to them. So if it's an easy hearsay objection, I'll say, what's that mean? And then Mr. Collins will explain, and then Ms. Kneppel will explain. The jury will go, oh, now we get it. The whole process of a trial is not just about facts, it's about educating them to do it right. But everything you're saying is exactly right. To circle back on specifics, your 8-page suggested questionnaire is about 4 right now. Okay? Like, I'll hear you out after I show it to you, and you say, I left some stuff out, and I'll say, yeah, you're right. But I don't expect to give the jury, prospective jurors, 8 pages, right? I've talked to some really nice clerks of court and jury commissioners who have told me how they want to do it, right? I'm just juggling that ball. I don't know where we're going. I just know what the options are. And then I have to account for how they do their system, very much how they do their system. So, like, everything you're saying, I appreciate, because when I give you short notice, you're going to wish you knew all this stuff ahead of time. And I don't know what short notice is. Like, I totally don't.
Do we know when the trial's set for?
Mr. Anderson?
No, not yet. They're still. It was supposed to be earlier this month, but then he granted the change of venue, but he doesn't know where yet they're going to go. I believe the prosecutor is appealing that decision as well as some other stuff. So,
Appealing the change of venue.
yeah. And some other decisions. So,
He seems pretty set in his decision. So clearly, he's going to take it regardless of where it goes.
yeah.
Okay. Interesting. I wish I'd seen the arguments for change of venue. That would have been interesting. I wonder if they did like surveys like they did in Idaho.
Yeah, we'll have to see, because I plan on trying to find some of the other hearings and go through them.
Yeah. Okay.
Just trying to figure, when we talk about the notices with the board as far as where we're going to go forward, and we're kind of just held up in advance right now, depending on the Board of Appeals, and whether there's anything after that Board of Appeals, from a logistics standpoint. And I know everybody has a lot of things going on, and everything's a little bit on hold. We have a heavy trial schedule. Also have some family vacation in March that's somewhat on hold, and gone 2 weeks in May. So I'm just not sure what we want to look for. If we want to look at dates as a potential trial, or, like, my concern is, I know this court wants to go forward. I know even over all of the cases, this is going to be a priority one, and we understand that. But we're just trying to juggle a lot of logistics and everything, kind of place that hold a little bit, just with our practice, especially if we're in a different community and living in a different town for the first trial. trial was roughly 4 months. We don't envision anything that's going to be during that length of time, but there's a lot of logistics that go into that. So I'm not sure if the court even did any definition. That we've been kind of on hold for a week in March, and we're kind of on 2 graduations that I'm contending with in May. So just trying to figure some logistics, but I'm not sure if we can have any of that definition right now because we're on hold, but I just want to bring it out.
But that's fair to you and me, and my docket, and your docket, the state's docket, right? Like I know when I am booked out for 2 weeks at a time, repeatedly, right? So like I'm going to try to not ruin your personal life.
Aw.
But like you gave up that when you took the oath of office as a member of the bar, right?
Well, this has a priority, and I understand that.
Yeah.
It's also trying to.
Yeah. No, I don't want to like have you miss like your family graduation. I don't know what I'm going to do. I just don't want to have to say that, like I didn't consider it. I don't know. I totally don't know. Like this is just me thinking out loud. We're either in limbo or purgatory, depending on whether you think we're getting punished.
I like
Or we're
that.
definitely in a hole, right? And then when we get out of limbo, then we have the adult conversation of like, okay, how's this going to play out? Like I told you last month, I'm going to go to bat for you when you say I can't be there because you have other clients that have high needs and other judges with high expectations, and I'm pretty sure that applies to the state. Everybody's supposed to be somewhere else.
Well, we understand.
Yeah, I'll try to work it. I get it. I won't just like throw dates on board saying be there until I have to. Right?
Fair.
Yeah, but you get things. Everybody, we have to talk. Like we're looking for the point of least resistance. So Corbin had the right idea. The fixed solid trial date. I mean, to the extent that you can say that he did, and he should have. Okay, what else you got? That's perfectly good.
Your Honor, just, you provided on January 14th a judgment entry with things to think about. So I took initiative and met with our client and went over each of those. And so for his sake as well as the court's, as a group, we do not have any competency issues right now at this point in time with our client. And I don't know if that's what you're indicating with regards to our client versus potential witnesses. I don't know of any potential witness competency. In terms of discovery compliance, the government has been very helpful with us. We may need help with where things are, things of that nature, because of the logging system. I think technology during the trial will take care of itself. With stipulations, Your Honor, we'd like to try to get those from the government as soon as possible, because that will help us in terms of that and concepts. We've already talked about the effects of judgment. We're fine with remote witness appearance as long as it's not going to order Jake. We're not going to object to anything other than that. The only defense extras we would have is depending on mitigation or not, Your Honor. We have gone over the ability to waiver a trial by jury. At this point in time, Your Honor, we would still like to have the jury process. I'm going to speak with him about that each time we meet with him. If that changes, we will let you know. And then we defer to the court with regards to media access, limitations, and expectations. Same with item J, Your Honor. And I think we've already talked about L, jury selection. So those are the things that we talked about with both our client and the court's knowledge.
Okay, thank you for running down the punch list. Let's get out any discussion about the punch list.
Just regarding the stipulations, Your Honor, I think it would be most beneficial and productive for us to sit down and discuss that as opposed to me just being like, here's a bunch of stipulations that you may or may not agree with, versus we come to an agreement about generally what we would stipulate about and then we have to come up with the stipulations themselves.
Anything else? Thank you for that. Mr. Wagner, first of all, I was not aware of a hearing issue, and I'm glad your lawyers raised it.
It's not really an issue, Your Honor, I'm legally dead.
There's been one, the other issue.
No, the other, one ear is done, the other ear is not very good.
How much of today do you think you heard?
Not much.
Okay, I got to know this.
Yeah, not much.
I got to know this.
Yeah.
I have to know this. So, anytime you have a problem, I have to know this.
Aw.
Your lawyers are right to say you're going to look at some sort of hearing assistance device, but I have to know this. So it's not rude. Anytime you don't hear, it's necessary for you to tell me there's an issue.
Well,
All right? So tell me anytime there's a problem. Understand? It's called accommodation. It's called like fundamental fairness. We say due process. I got to fix it, whatever that means. Right? So that's first cousin to competence. Like I've been watching you, not staring you down, but necessarily like everybody in the room, I'm doing the survey. I have to like be responsible for the fight that I don't see coming in the corner. I have to pay attention to you just because it's a part of my job. So far, you've been well-mannered.
I was wondering what this guy's shirt said, apart from DRC. Apparently 5X, so I'm guessing that's the size of his shirt, so oof. Okay.
Appropriate, attentive. So thank you for that. A lot of defendants can't do any of those. Understand? You're well-mannered. You're acting appropriate. You're well-mannered. It's a good thing. Understand?
Well, most times in here, Your Honor, y'all might as well be speaking Cantonese or Mandarin, but I don't catch it.
Yeah, well, when we go law nerd on you like we did today,
Huh?
when we talk like lawyers and technicians, yeah, like half the people in the room might not understand the words, although I think a lot of this was common language. We have to make sure we explain things, and your lawyers have to tear it down and build it up again. So I'm assuming they go back and explain and answer your questions, right?
Yeah.
Like, are you satisfied with your lawyers?
Huh?
Are you satisfied with your lawyers?
Yeah.
Like, I think they're doing a fine job, but it's not my lawyer, it's yours.
Yeah.
Okay? Like, if there's ever a lawyer problem, tell me that also. I don't see it, but I need to know if you have an opinion to the contrary.
No.
Like, I haven't tried a case with any of these lawyers. I know Mr. O'Brien because you can't not know him. I know the reputation of your lawyers is good, so that's a good start, but it's your case. Your opinion is important. So you have to tell me if there's a lawyer problem, all right? Same way I need to know if you can't hear. In my former courthouse, every time the fire department made a run, we just stopped
Aw.
because the echo was insurmountable. This courtroom's better than that one. So it works. But if there's an issue, I got to own it, deal with it, fix it. All right? Now, here's the next thing, and then I think we're done. I don't get involved immediately in plea negotiations. I don't have an opinion whether there should be one. I brought it up in August because it's on my list of duty. My job is to make sure that box gets checked. There's no obligation on you or the state to enter a plea negotiation. So I don't have a preconceived notion about how this is going to end. I know if I don't talk about it, I didn't check the box of being thorough. Understand? Yes?
Yeah. Yeah.
Okay. So that's a part of it. How the lawyers want to set the case up is up to them. Here's where that changes. Lawyers negotiate thinking that that's the outcome, when in fact, at some point in time, they have to bounce that negotiation off the person who doesn't have to accept it. Were you involved here about the sentencing 3 weeks ago? Do you know what happened to your wife and son?
No. Oh, yeah, yeah.
Do you know what the sentences were?
Huh?
Do you know what the sentences were?
Yeah, they told me. They told me.
Okay. Like, I don't, that's all you do is need to know.
Yeah, I know they, yeah.
That's called context.
Yeah.
Doesn't mean that's what's going to happen to you. It's just knowledge. It's context. You understand that?
Yeah, I understand that.
So, like, if the lawyers want to negotiate something, that's fine. If they want to bring it to me, they need to, because my job is not to sign off blindly on what other people think I ought to do, because judges are independent. Now, I understand Ms. Canepa didn't have a mutually recommended sentence imposed. That's how it works. Nothing went wrong. That's how it works. So if you want to negotiate, that's fine. If that happens, they know to talk to me. Understand?
Dude, after the sweet ass deal that was given during sentencing because they pled, I don't know why this guy is still trying to take it to trial, quite frankly. The judge overruled a life in prison plea deal and gave him like 30 years before parole. So if I was him, I would be very eager to have the judge sentence me with taking a plea deal, but we'll see.
You understand?
Your Honor,
William Davis.
Aw.
you know, I understand that perfectly, and they explained that to me fine, but,
Hey, Relic
Yeah,
Bravo.
it's related to me. Yeah, I'm good.
And so the record's clear, Your Honor. Anytime we have something that we believe is going to happen in the next month or the next quarter, we go in advance and explain it to so that he can process it. It's not a volume thing, it's a processing thing. And Lieutenant Carver has been nice enough to give me information so that the hearing aid issue will happen rather quickly, so I appreciate that, Your Honor. And so the only issues we have in terms of
Phoenix
our
controlled.
what I believe our ethical duties are with regards to negotiations with.
I wouldn't be surprised.
So that's the only time that those restrictions just to let the court know.
Yeah, fair enough. I don't have any input in the negotiation. I get the outcome. Anything else you want to talk about, Mr. Collins?
No.
Mr. Hayes?
No.
Mr. Gadsden? Mr. Gadsden?
I have a question for the court
Yeah.
that I think would be beneficial for all of us to know. I fully understand that the court has previously told us on record in chambers and, through contact, I guess, that we can negotiate agreements or pleas or whatever. This court obviously is going to independently evaluate that and make its own arrive at its own conclusion. Does this court, say for instance, they say, oh yeah, well, he's only treated as whatever, that's great, immunity, whatever. Would this court let the council know if you were inclined to go along with it or not? If it so deeply offended you that you would not, or do you simply don't do that and you all find out at the same time? Do you know what I'm saying?
I'm going to answer that.
Okay.
Okay. Do you have anything else, Mr. O'Brien?
No, Your Honor.
Ms. Gall, do you have anything you want to bring up? Okay, so here's the honest answer. I don't know who's safe. And you don't know if I'm safe. And that's the way it's supposed to be. It's not fault. We don't have familiarity. You can call every defense lawyer that practices in front of me and get their opinion. You can call every prosecutor and get their opinion and sift it as best you can. But when it comes down to safe, every case is like a new experience. So I haven't ambushed anybody. I've signaled, whispered, and nodded, and talked on the record and explained the philosophy, but never made a commitment because you can't. Like, I think you're all safe to talk to until your words don't match your actions, which is why I gave you the question last month, rhetorically, am I supposed to believe what lawyers tell me? I don't really want to answer. I don't think anybody did anything wrong. I think the circumstances got to the point where nobody could deliver on what they were saying. I'm good with that. That's how difficult cases are. So if you have a proposal, then we have to decide if we put it on the record, if we go back and huddle up in chambers, because most of my colleagues would say when you talk in chambers, all you ever do is get thrown under the bus. And those discussions are helpful until the judge gets thrown under the bus. I didn't pre-decide anything. I talked about philosophy. I talked about how I look at the world. That's just meant to give you some idea. So then you decide if you have a plea negotiation, where we do it, and I still won't commit to it. But I won't let the court system, the judge, get thrown under the bus for trying to accommodate lawyers. Ain't gonna happen. I found no lawyer to be disrespectful at any point in this trial, this process.
This one hearing, I mean, the last one, the prosecutor was kind of a bitch, but, you know.
I have colleagues who have different opinions about what they would have allowed in their presence. That's okay. I don't care about their perspective because they aren't responsible for the outcome. So we're good. Like, I'll tell you, you know me well enough, I'm going to lay it at you, not circle around behind you. And then you can just deal with it. But like I said earlier, every assignment of error starts out the trial court error. It's not my goal to get out of bed and make mistakes that day, but I do. So you keep
I make enough in bed.
Try to make a better experience for the public and the defendant and the victims, and we'll get a fair outcome, whatever that means. I got no opinion on trials, please. I'm playing this out the way we have to get it done right. So yeah, I want to hear if you have negotiation. We just have to figure out what is safe in doing it. And I have a legal duty to not just sign off blindly when I check my friend at the door. Good point. Anything else? All right, Mr. Wagner, thank you very much for your attendance. Thank you to the court staff and security folks and the transport. Off the record, please.
Thank you,
This guy really should iron his shirt before he comes to court. Very disrespectful.
Yeah, they're allowed irons.
It's all wrinkly, sir. And maybe get a suit next time. I believe he's probably almost 50.
Who knows? He's in a wrinkly skin suit. I know that. Wrinkly fat skin suit.
They really need to ban male Instacart shoppers. I specifically asked this man before he left if he got everything, and he said yes. Oh, so Hella, you are.
Shortly. Yeah, we're going to be streaming the cross of Scott in the Farris trial,
Woohoo!
but not just yet. Can we please have a bit of a look at? I need to understand this. I need to understand a little bit more about this. Stolly, can you pull up? Do we have anything about the actual crime, please? Because I'm just a little bit lost.
Sure. Hold on one sec.
This is all just over my head. When did it happen? Who done it? Yeah, who done it, Dali?
Okay.
Yeah.
That's what you want to know.
Give me the basics.
Chronological breakdown of one of the biggest cases in Ohio history. All right. So, this is from a while ago. Friday, April 22nd, 2016. 8 members of the Rhoden family, or Rhoden family, were found shot to death in their homes. The crime scene spanned multiple family homes throughout the area. 7 family members were found deceased in 3 different homes. The 8th victim was found within a 10-minute drive of the others. 3 children, a 4-day-old infant, 6-month-old, and a 3-year-old were found unharmed in the homes because clearly they're not monsters. So eventually the family is discovered, and here's the 911 calls.
Can we watch that little clip?
This one?
And for the first time, we're look like a large barn on a separate property, but very nearby this Union Hill area. And so Dan Carroll's up in Chopper 9 right now.
And he continues to looking over the scene you're talking about. So that's the 3rd area. And we toss it up to Dan with the very latest. And do you see what type of
So Dan the man's in the Chopper 9, and he's looking at the property. And of course, there are numerous cars on the property. I'm sure they're on bricks.
activity do you see from your perspective there, Dan?
Well, yeah, this is during the commercial break. Couple of breaks ago, I was looking around the area even farther out, and then we're about another mile or so down the road, and then we see this trailer home, which
$20 that there's a still in there.
has crime scene tape around the front of the trailer home, and we saw some what appeared to be police officers and investigators out front there. And then while Jay was talking, we saw this area that appears to be, looks to me to be a junkyard, and we see a mobile home and then a large barn, and then we saw a couple of guys in what appeared to be hazmat suits and a couple of other personnel walking through the woods back to what I think is a barn partially blocked by these trees. I'm going to have to go around and get a better look at that, but they walk through between the home and the barn you see in the picture here, and then back into this area, and there you can see the two men in the white suits, the white jumpsuits, looks like the biohazard suits out in this area, and it looks like
the biohazard suits had nothing to do with the brutal murder. It was because they were just on the property and were really creeped out by it.
Yeah, well, they walk around like that generally.
Well, I mean, just anybody who visits the property feels like it, even when they were still alive. So,
like they may appear to be entering another structure on this piece of property. So earlier, when we were talking about the possibility of 3 different crime scenes, I think we've figured out now exactly what they were talking about. We saw the one home earlier where the majority of the police officers and investigators are gathered. Then about a mile down the road, there's another mobile home and then a second mobile home. And this mobile home is in front of a junkyard. And now it appears they are looking into another building that is on this property. It looks like, to me, to be another barn that they're looking at least checking out the perimeter right now, and maybe preparing to go into that building to find some additional evidence. So we were talking about that earlier, about how widespread this crime scene is, and now that we've had a better chance to get a look at it, we can tell you that is exactly the case, that this is spread out what appears to me to be over about a mile or a mile and a half.
Wow.
There's never been a case in Ohio history like this.
I just lost a tooth. Oh, sorry, just lost my last tooth.
Okay, so these other people who are involved, they pled out,
Yeah,
right? So this is the only dude left?
I believe so.
Okay. And so he's decided to go not guilty and go to trial, and
Yeah.
that's it. He's the only one.
Unless I'm mistaken, chap, but I believe so. Because most of them,
Basically, they shot anyone who could fight a custody battle with the grandma.
Okay.
Okay. America. God. This is really bad.
Yeah.
I feel a little bit bad making fun of it, to be honest. But, I mean, what are you going to do?
Yeah. Then we'd have to actually look at the horror of it, and I don't want to process that.
Yes. KLF, mum and younger son, dad in the custody battle took deals. Older son went to trial. The older son went to trial. Thank you, KLF.
Yeah, in 22.
Got you.
And he was convicted, life in prison.
Okay, so he got life in prison, right? Okay, so we've got one that's got life in prison already from a trial, right? So this whole waving around the death penalty thing with this one, with the dad, wouldn't that be very unfair for the dad to have the death penalty and not the son?
I believe...
Isn't that part of the argument? Because, like, what I've heard about this, and I'm really sorry that I'm not up with it like other people.
Sure.
But what I've heard about this is there's some anger in the community that there's no death penalty, right? But I think from the judge's point of view, it's like, well, not only a due process thing in terms of you can't just chuck the death penalty in at the last minute, but also there are other people who are culpable here who've had life without parole, and then are you just going to have the death penalty for one person? How does that work? Okay, so KLF, yes. So death penalty was taken off the table for son's trial because prosecution messed up.
Okay.
And that happens. Valid bail situation. So what? Like a discovery violation.
Yeah.
And of course, you've got the community going, shoot them!
Yeah.
Lethal injection! All that kind of stuff.
And they got away for a couple years. They moved to Alaska.
Really?
Yeah. To try to, wait for the pressure to come down and...
Really?
Yeah. So, yeah, they weren't arrested right away.
Huh.
They thought there was, marijuana connections at first because they had marijuana farms on the land. Go figure.
Really, Angie? You're in that community. You're like, you want them dead. And Cool. Like, if that's your position, I'm not judging you.
Yeah.
Not judging you.
I mean,
I'm fully anti-death penalty over here, but I respect other people's opinions.
yeah.
Rachel says this was planned for a while. Guns, burner phones. Silence.
Yeah. I mean, yeah, the grandmother was crazy and wanted the kid and just white trash. So I'm not really.
In a way, I want to know more about it. In a way, I don't. Sounds really horrible.
Yeah. It's pretty brutal. Or it is brutal.
Yeah.
Yeah, I'm just kind of interested in the judge and seeing how he handles everything going forward. That's kind of what I'm interested in.
Yeah, the judge does seem pretty interesting. Like,
Yeah.
I haven't come across one like him for a while.
Yeah.
Caleb says, how the 4-day-old
Yeah.
was in the bed with her parents when they were shot. Yeah, that's terrible. That's unspeakable. The 4-day-old survived. Can I ask?
Yeah.
Okay.
All the kids survived. Because I guess they didn't have to worry about a custody dispute with them.
Okay. Wow.
Yeah.
What's up with Hella's mic buzzing? I have a fan on, so that's amazing that you can hear that, right? Because like that's really interesting because no one's actually said that yet. Maybe it's
No.
because it's quiet and there's no video
Probably.
happening at the same time. And we have had like noise from the court.
Yeah. I think it's only when you like talk, I kind of hear that buzzing.
Oh, right.
Yeah, I don't hear it right now.
You can hear it too. Angela can hear it too. Yeah. Maybe if you've got earbuds in or you're hearing like you've got
Yeah.
got good sound.
It's very faint.
Yeah. A fan in the winter. It is so far from winter over here. I'll tell you what.
Yeah. Hella's been very angry recently. It's been so hot.
Speaking of angry.
Yes.
Speaking of angry, I have an anger challenge happening on my next stream.
Oh boy.
We'll talk about that in a moment. I'm going to pop over there.
Okay.
This has been fun, kind of.
I
in a
will.
macabre kind of way.
Yeah. I
I'll
will
see
see
you
over
guys
there.
there shortly. Okay, bye.
Alrighty. So yeah, I will be ending. Heading over there. Yeah, it's a redirect's all set up, so that's cool. Next week, I'll continue my court stuff as I do Judge Fleischer. I'll get back to hopefully covering Judge Simpson. We have Buster coming up on the 30th. Hopefully hear from him and the cold case in Michigan. And then I'll do some more of the Wagner pretrial hearings that have happened because it's kind of interesting to see a judge that's protecting the defense more than you usually see. Whether or not you agree is okay, but I find it fascinating. So, all right, I'm going to end now, and I will see y'all over at Hella's, I hope. Half Irish, you are amazing. Yes, the link in case my redirect doesn't work. And knowing me, there's always that chance. So, there you go, guys. All right, see you there. Oh, yeah, I saw Mavka. I'll check that out. Thanks. Appreciate it. Bye.